We are live. Sorry, everybody. I was the host, and as you might have known from past broadcasts, when I'm the host, things go wrong. So, sorry for being a minute late. Zach New here, Aaron Hall, Jennifer Howard over to my left, right, and here to bring you some updates for the immigration world the last week. So, I don't know, Aaron, you want to kick us off?
Well, sure. I am going to talk about a case that came down from the Board of Immigration Appeals. And when the Board of Immigration Appeals makes published decisions, which this one is, it basically creates new binding law and policy on immigration adjudicators. And the case that came down this week is called Matter of Fernandez. It's with an F, but you get the idea. And it's the latest installment in this ongoing saga where basically immigration lawyers and their clients are arguing that the notice to appear that was issued by the Department of Homeland Security is deficient. And the notice to appear is the charging documents that put somebody into removal proceedings or deportation proceedings. And what the law says is that it has to contain certain information, including the date and time of the initial hearing. And for years, or more like decades, the Department of Homeland Security ignored that, and they just issued it with something that said TBD on the date of the first hearing. And over the course of the last few years, there's been a lot of decisions, more than I can count on one hand, about what happens due to their failure to comply with the statute. And what the Supreme Court has said is that the notice to appear without that information isn't actually a notice to appear at all. It's not a charging document. That said, it's been sufficient to get people into proceedings, to give jurisdiction to the court. And what the Board of Immigration Appeals said in this case, Matter of Fernandez, is that if the non-citizen timely objects to the deficiencies in the document, that the Department of Homeland Security can be ordered by the judge to fix it. And then they kind of just left it at that. They said, well, we don't really know how they should fix it. The Department of Homeland Security has all kinds of internal regulations and policies that we're not privy to, so they can figure it out. And it's really interesting because there's a dissent in this case that said, well, they shouldn't be ordered to fix it because it's going to cause chaos. And what the dissent said is the regulations don't allow the Department of Homeland Security to file a second NTA into the same case. There's no authorization to do that where the first one is deficient. And because of that, the dissent says this means that they're going to have to terminate the case. The immigration judge is going to have to terminate the case. And then if the Department of Homeland Security wants to start over, they can. They can file a new NTA that actually complies with the law. So what does that mean for the 1.8 million cases, the vast majority of that are pending in the immigration courts, the vast majority of them with these deficient NTAs? Well, we're not sure yet, but we are certainly going to be pushing this argument in appropriate cases that the NTA is deficient and that the judge actually does need to terminate the case. And we have actually started kind of working through one of those motions today already. And how the judges are going to receive that, I don't know. But I think the main point is that it gives new arguments to cases that might not have had them before. And it's particularly important to cases where maybe they don't qualify for relief from deportation right now, but maybe they could if they had a little bit more time. And so these are new arguments to cases that previously, might not have had much of an argument. And so we're analyzing that for our current clients. But if you are in removal proceedings or know somebody who is, it's definitely worth taking a look at with a lawyer and seeing what this new case means to the possibilities. So if you have that situation, or if somebody you know does, definitely feel free to schedule a consultation with us, and we'll take a look at it and see what might be able to be done.
Thanks, Aaron. Sorry, as I said, when I'm in charge, things don't go well. Banners, not something I'm good at. Jeff, you want to jump on next?
Sure. So this week, actually the 15th, marks the 1-year anniversary of Kabul, Afghanistan falling to the Taliban. And so if everyone recalls, on August 30th of last year is when the U.S. officially withdrew, like completely, completed its withdrawal from Afghanistan. And I think, as a lot of us know, and we've talked about this a bunch of times on here, there's still a lot of people trying to get humanitarian parole to come to the United States, and all of those cases are still pending. I haven't had one adjudicated yet, even though it's been almost a year now. But last week, a bipartisan group of 6 senators introduced a new version of the Afghan Adjustment Act, which is legislation that would allow people who have evacuated to the United States and are here, which I think is about 76,000 people, they estimate. It would allow them to adjust their status to lawful permanent residency. And obviously there would be, certain requirements for that, and security, background checks, vetting, all of that. But if it goes through, it could, provide some relief to some of the people that are already here. Hopefully, we'll know by the end of the year if that's going to pass. There was a bill previously introduced that, was rejected by the Senate previously. So we'll see what happens. But yeah, just wanted to give that update. Yeah.
Thanks, Jennifer. And yeah, I also have humanitarian parole cases that have been pending for 11 months now that still have absolutely no action on them. It's ridiculous. They paid so much money for these cases to be adjudicated, and I think the most recent stats I saw were less than 200 have actually been approved. So absolutely just ridiculous. So hopefully you get something out of Congress that fixes this. But it's also interesting to kind of contrast it with Ukraine, where we got United for Ukraine that has permitted, what is it, like 60,000+ people so far who have entered the U.S. Pursuant to United for Ukraine. It takes like 4 or 5 days to get a decision on these specialized humanitarian parole cases for Ukrainians. Not that we would want to take away from that. I think it's a great thing. It's just that's I think noteworthy that there's such a disparate treatment of these two groups. Anything else to add on that, anyone? All right, well then I'm going to talk about something really boring. In the business immigration world, there's a thing called an I-9 that you have to fill out every time that you go and get a job. Very often, when you do this, it's your driver's license and your social security card that you bring along. It shows who you are, and it shows that you are authorized to work. During COVID, it's been a bit of an issue. Everybody's been working from home. A lot of places are having remote workers that are very far away from their headquarters. So having these documents that have to be physically examined by a person filling out an I-9 has been a challenge. We've had employers that maybe you're headquartered in California and you're having a worker who's in Kentucky, and you've got to find a way for an authorized representative then to fill out this form for you, fill it out properly, and then sign under penalty of perjury that everything was proper, that the documents looked genuine on their face and were reasonably related to the person representing them. It can be difficult to do. Just asking just some random person to be kind of signing a document under penalty of perjury, potentially subjecting them to liability. So it's a big ask. There was some flexibility, though, that the Department of Homeland Security put in place during COVID that allowed for fully remote workplaces to have remote verification, as long as after things kind of normalized, they would physically examine the documents that were presented. It's helpful. It's been helpful, but it's not been a cure-all for sure. Because if you have partially remote work, for example, you couldn't use these remote verification tools. Cause a lot of issues. And it's an important thing too, because if you do your I-9s improperly and ICE decides to audit your documents, you can be fined thousands of dollars per violation. It can be a huge penalty if there's been kind of like a systemic issue with how you've been completing your I-9s, or if you've been hiring people who are not authorized to work because maybe you just didn't realize that this type of green card is invalid. This is not how a green card actually looks, and you've been accepting it for years now because you just didn't know. So I guess the big issue is that we've got a remote workforce increasingly during COVID and kind of continuing now, people working from home, and not really a great way to deal with that. So over the last couple of weeks, past couple of months, really, the Department of Homeland Security has been pushing out some proposed changes to the I-9 form. Some of them are, kind of just, I guess, technical. Like, we're going to reorder this, put the preparer page at the end as an addendum. Try to make this a 3-page document instead of a 4-page document. Just try to make things a little bit more efficient, which is great because the form is confusing sometimes, and especially if you're not somebody who's a native English speaker or somebody who really realizes how important these documents can be. And the most recent one just came out today is a proposal to allow for remote verification of employees. There's not very many specifics about what that would look like. It's very much saying, we are proposing to have regulations that would allow for remote verification depending on how the Department of Homeland Security wants to actually implement them in the end. But it's a step in the right direction. It's open for comment, and right now you can actually go on to the website and put in a public comment saying it's a great idea, it's a terrible idea, and this is why. The Department of Homeland Security is required to respond to those comments, so it's a way for you to kind of affect change and make a difference in how the laws actually come out in the end. So if you have strong feelings about I-9s, which I know not many people do, feel free to head on there and send in a comment. But it's going to be big news for employers who have a lot of remote workers. It could be very game-changing for a lot of people. So it is big news, even though it's kind of boring news for most people. But hopefully going to really reduce the amount of violations that we see as work from home becomes more common. There's the fun update. See, we don't have any comments. Anybody have any notes on my fun I-9 discussion there?
I don't think so. I have notes about your performance as host of the stream today.
Ryland's supposed to be on for these types of things. I had to figure out how to log in.
I also feel like you kind of do it in the dark to try to.
I got a lamp that's specifically purchased so that I wouldn't be so dark, and this is the result. I mean, I lurk in the shadows. That's what happens when I get put in the basement.
Well, all right. Thank you for joining us. If you watch this later and have questions or comments, contact our office. You can set up a consultation. We're happy to talk to you. And otherwise, if you want to get questions in, we'll be back here same time next week.
Thanks, everybody.
Thanks.